Hello, and welcome to All Things Chemical, a podcast produced by Bergeson and Campbell, a Washington, D.C. law firm focusing on chemical law, business, and litigation matters. I'm Lynn Bergeson. This week, I'm excited to discuss with my colleague Kelly N. Garson, a senior associate here at Bergeson and Campbell and a regulatory consultant for our consulting affiliate, the Acta Group, the implications of the demise of Chevron deference, especially as it relates to the Toxic Substances Control Act and all the litigation underway involving TSCA. We discuss what Chevron deference is, other types of deference that are still very much a part of judicial review, and how Chevron's elimination could impact the implementation of the 2016 amendments to TSCA, given the many issues in dispute now pending before a host of federal circuit courts. Now, here is my conversation with Kelly Garson. Well, Kelly, welcome to the studio. I've been so looking forward to hearing your thoughts on Loper Bright and the demise of Chevron deference. Maybe you can help our listeners understand a little bit about your background, and so tell us a little bit about yourself.
Sure. I'm a senior associate with Bergeson and Campbell. I've been a part of BNC and the Acta Group for about 5 years now. Within that time, I've worked on issues under nearly every section of TSCA, including representing clients in judicial challenges under TSCA Section 19, and I've worked on a variety of chemical regulatory and product stewardship issues.
Well, you're very modest, Kelly. In addition to being a brilliant attorney, you have been spending the last 5 years slavish in your devotion to the intricacies and nuances of TSCA. So I'm thrilled that you're able to expand upon some of your experiences today. And the reason we're having this conversation is that we're approaching the 1-year anniversary of Loper Bright Enterprises versus Raimondo, which was a June 28, 2024 Supreme Court decision overruling Chevron v. NRDC. Now, the lawyers listening to this podcast will remember how the legal community pretty much lost its mind when the decision was issued. It was just all over the trade press and legal journals. I think it was widely anticipated, at least many of us thought that Chief Justice Roberts would overrule Chevron because that seemed to be all of the messages that we were getting from the Supreme Court. But maybe you can help our listeners understand what Chevron deference is, what is the so-called two-step process that no longer applies, and what are courts now required to do given the demise of Chevron?
Sure. So Chevron deference emerged from a 1984 Supreme Court case, which was Chevron USA versus Natural Resources Defense Council regarding an issue that arose under the Clean Air Act. So after this decision came out, the case established a two-step process that became a foundational principle in administrative law cases for answering the question of when a statute isn't clear or hasn't spoken on an issue, and there's multiple potential interpretations of the statute, who should have the final say on whether or not the interpretation should stand or should be struck down? Is it the administrative agency or is it the reviewing court? So in the Chevron case, the two-step process sought to strike a balance between determining when, for example, one underlying principle, for example, was, did Congress delegate interpretive authority to the agency and not to the reviewing court? So the two-step process went like this. So first, the reviewing court would determine whether the statute was clear, ambiguous, or silent on the issue. If the statute was clear, meaning that Congress had spoken on the precise issue, then the court was required to effectuate Congress's intent, whether or not the agency agreed with the interpretation. But if the statute was determined to be ambiguous, or if it was silent on the issue that was under review, then the court was required to determine whether or not the agency's interpretation was a permissible construction of the statute. So oftentimes this was defined as whether the interpretation was reasonable. So that means that if there are multiple interpretations of the statute under Step 2, and the court disagreed with the interpretation set forth by the agency, it would still be required to sanction the agency interpretation, even if it departs from what the court considered to be the best reading of the statute. So now that Chevron has been overturned by the case Loper Bright, to answer the question, what are courts required to do now, that best reading of the statute language has become very important. The major line of thinking in the Loper Bright decision is that it's the responsibility of the judicial branch to decide what the law is. So that means that reviewing courts cannot presume that congressional silence or ambiguous terms in a statute means that Congress intended for the agency to decide those issues. This means that instead, the courts cannot defer to permissible agency or interpretations and must apply their own reading of the statute and what constitutes the best reading of the statute.
So that was a very helpful description of what Chevron deference was, and I can appreciate why the Supreme Court made the decision that it did. And as noted, it, to some of us anyways, came as no surprise that Chevron was going to kind of be ushered out the door, because it basically is required that the agency's interpretation was the court was bound to determine or rule in favor of whatever that agency interpretation was, which really raised some profound questions about Article III jurisdiction and various provisions of the Administrative Procedure Act. And to bound the court to an agency interpretation under those circumstances struck many as just being an excess that needed to be corralled. And there are lots of indications in the Supreme Court cases preceding Loper Bright that gave us every indication that this is exactly what Justice Roberts' courts would do, and it did. Well, to help listeners better understand the core of Chevron deference, maybe you can give a court's application of the doctrine in an actual case. Are there any that come to mind, Kelly?
Sure. So one case where the reviewing court applied the Chevron doctrine under TSCA was the case challenging EPA's first risk evaluation framework rule from 2017. So that case was Safer Chemicals, Healthy Families versus EPA, and that was reviewed by the U.S. Court of Appeals for the Ninth Circuit. So this issue tied in how EPA would interpret its requirement to evaluate chemical substances during a risk evaluation under the conditions of use, which are defined as the circumstances as determined by EPA under which a chemical substance is intended, known, or reasonably foreseen to be manufactured, processed, distributed in commerce, used, or disposed of. So what happened during the legal challenge of the framework rule was an issue was raised as to whether EPA violated TSCA by excluding category of activities known as legacy activities from the definition of conditions of use. So legacy use, the term doesn't appear in TSCA. So what ended up happening during the case was considering whether three different types of activities, which were legacy uses, associated disposals of legacy uses, and legacy disposals, whether or not those all fell under the conditions of use that EPA was required to evaluate by Congress. So in order to determine whether or not this was correct, as in whether EPA had violated TSCA by excluding these three types of activities, the court ended up applying the Chevron framework. So for step one, Congress was required to ask whether Congress had spoken to the precise issue, which was whether or not these three legacy activities were improperly excluded from EPA's evaluation. So looking at TSCA's definition of conditions of use, the court found that the definition was unambiguous in terms of two activities, legacy uses and future disposals. So that would be, for example, a legacy use of asbestos insulation, where asbestos was no longer manufactured for use as insulation. It existed in existing building insulation. So that would be the legacy use. And then the associated disposal would be future disposal of that asbestos insulation into a landfill. So under step one, the court said the statute here is clear. TSCA applies to current or future uses or disposals, even if a chemical substance is no longer manufactured for that purpose. And they said that Congress was clear that EPA was required to evaluate legacy uses and associated disposals. So that issue was resolved in step one of Chevron. But that left the issue of legacy disposals, which the court determined was not clear or unambiguous. So then for that issue, the court proceeded to Chevron step two. So under step two, the court's required to defer to an EPA interpretation if that interpretation is reasonable. And so EPA's view was that legacy disposals, which would include, for example, asbestos insulation that was already that had already occurred. So asbestos insulation that was already placed into a landfill. EPA determined conditions of use did not extend to legacy disposals. And in its review under step two, the court determined that TSCA clearly covered current and prospective activities, but it did not require EPA to address a substance that had already been disposed of in the past. So some of the questions here was, well, how do you define disposal? Does disposal refer to a one-time occurrence or the physical act of discarding a substance in a landfill, or does it remain ongoing after the initial act of discard when it remains in the landfill? So TSCA doesn't say. So the court concluded that it didn't need to weigh in on this issue because since a legacy disposal doesn't need to fall under the statutory definition of a condition of use, EPA's decision to exclude it from the risk evaluation was permissible.
That was really helpful, Kelly, to understand the step one, step two. I hope our listeners found it as helpful as I did. Well, so Chevron deference is clearly gone. Chief Justice Roberts' decision in Loper Bright said that Chevron was overruled because it committed a multitude of sins. It violated Article 3 of the Constitution, establishing, judicial review and the federal judicial branch in general. It violated Section 706, of the Administrative Procedure Act, which deals with scope of review. And it violated Marbury versus Madison, widely regarded as the case establishing judicial review writ large. And also, according to Roberts, it took away from the federal judiciary its solemn duty to say what the law is. This is very clear. And to the extent I've read the decision several times, it seemed to be most compelling when Roberts identified the fact that courts were required to defer to agency deference under the circumstances that you've so carefully laid out, Kelly. So to that extent, Justice Roberts' logic seemed quite persuasive to me. But I want to make clear that Chevron deference is one of several different types of deference that have been identified in judicial decisions over the years. So maybe you can help our listeners understand what other forms of deference remain very much a part of judicial review. What, for example, is our AUER deference? And as we noted in our article on this topic, we issued last July and will be made available to our listeners, there are other forms of deference in addition to Chevron and our. So help us explain what's going on here.
Right. So this question ties in several important issues that will help stakeholders understand the landscape of litigation under TSCA and other environmental statutes in this post-Chevron world. So as you noted, there were three main forms of deference in administrative cases. So that was Chevron deference, Skidmore deference, and Auer deference. So the form and level of deference that applied depended on the type of agency action subject to the issue. So, for example, Chevron deference or Skidmore generally would apply if a lawsuit addressed an EPA interpretation of a statute that the agency was tasked with implementing. If the lawsuit instead was addressing an agency interpretation of its own regulation, then the doctrine under Auer deference would apply.
Mhm.
And even among those three, there are still the different types of deference that are afforded under the standard of review for a particular case. So, for example, if a case is brought under the Administrative Procedure Act, based upon the type of action at issue, for example, whether the agency action and the judicial challenge concerns factual finding or a discretionary decision, the court will apply a standard of review for that action to determine, for example, whether the agency decision was arbitrary or capricious or an abuse of discretion, whether it was supported by substantial evidence or unwarranted by the facts. So these varying standards of review, the level of deference afforded to the agency depends on the stringency of the applicable reviewing standard. But in terms of what will hold in the absence of the Chevron deference doctrine, the court in Loper Bright cited to Skidmore deference. So Skidmore was generally viewed as a weaker form of deference than Chevron, and it preceded Chevron by several decades. It emerged from a 1944 Supreme Court case that held that there is deference that's afforded to an agency's informal interpretation of a statute, but the weight of that deference is afforded based on factors such as the thoroughness of the agency's consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and other factors which give it the power to persuade a reviewing court, but not the power to control, meaning that based upon those factors, the court could give more or less weight to the agency interpretation, but ultimately it's meant to persuade. The court is still required to use its own independent judgment to decide what the best interpretation is. So, under Loper Bright, the reference to Skidmore indicates that there will exist some level of deference to an agency interpretation, but not traditionally as in this is a permissible or reasonable interpretation. So this is the interpretation that must hold. Instead, it's more what factors are persuasive in this interpretation, and that is a tool that the court can use in evaluating its own decision. It ends up being an additional part of the record for the court to review in making its decision.
Well, that seems to me entirely logical that, courts are always going to give some deference to courts or agencies that have specialized knowledge and expertise built up over the years. And Skidmore is a way of honoring that expertise and giving the various factors that you've enumerated, Kelly, the deference and the weight and the persuasiveness that they deserve. So it sounds like Skidmore's not at risk, although I've seen some law journals that would say, if Chevron's gone, Skidmore's the next to go. What do you think about that?
I think in terms of Skidmore, it's in, for example, a recent case, which was Environmental Defense Fund versus EPA, for example, which was a case under TSCA, and it challenged EPA's 2023 rule to carry out TSCA Section 4 confidentiality provisions. In that case, there was a reference to some of the Skidmore factors, which included issues like consistency and past pronouncements, for example. So I think in terms of Skidmore, it seems as though that case strikes a balance that Chevron didn't, which is to use the agency's interpretation as informative rather than controlling, which is the
Yeah.
basic premise there. So it's possible that Skidmore could remain present in cases that are trying to work out the new framework under Loper Bright. I know in terms
Mhm.
of our deference, so the standard that applies when an agency has issued an interpretation of its own regulation, I know there has been a bit more legal conversation as to whether our deference should remain as it is, given some of the same underlying concerns about the role of the court versus the role of the agency, and it's the role of the court, not the agency, to issue a final say um,
Mhm.
regarding interpretations that carry and ultimately carry the force of legal effect upon stakeholders. Um, so I think there will likely be more discussion relating to our deference, for example, and it seems as though Skidmore might become more wrapped into the type of review that's applied under Loper Bright.
Got it. Well, and that we're starting to veer into the heart of this discussion, which is one of the central questions we attempted to address in our article that was written shortly after Loper Bright was issued. And that's how much the demise of Chevron will make a difference in the growing number of cases involving Tosca and the court's interpretation of EPA's implementation of the 2016 amendments. I think our initial response in the article was, well, of course it's going to make a difference. And we offered several suggestions to readers in the article of advocating how do you go about parsing these issues and presenting your advocacy in a Chevron free world. And you've already indicated, at least in one case, the EDF v. EPA case, how Loper Bright might make its mark there. So maybe you could expand a little bit upon that case and also Vinyl Institute v. EPA, a July 2024 case that involved a case of first impression. So why don't you give us your thoughts on those two instances where Loper Bright, I think, did influence the court's decisions in one way, shape, or form, with Vinyl Institute first.
Sure. So Vinyl Institute only came out a few days after the Supreme Court issued the Loper Bright decision that struck down the Chevron doctrine. But the Vinyl Institute case, um, it's it's an interesting case study in what a post Chevron review might look like. Um, so, so for some general background on the Vinyl Institute case, this was a case of first impression challenging EPA's authority to issue test orders under TSCA Section 4A2. So here, the case had raised several issues relating to EPA's implementation and interpretation of requirements directly under TSCA, so the language of TSCA Section 4A2. And ultimately, the DC Circuit decided to vacate EPA's test order challenged in the case based on the fact that there was a lack of information in the public administrative record demonstrating that EPA had met all of the statutory requirements needed to issue the test order. So, specifically, for example, this concerned the mandated statement of need for a TSCA Section 4A2 test order that included information such as whether EPA reviewed reasonably available information that would inform its decision that new testing was required, for example. So for several issues, the court found that EPA did not show its work, for example, in the public administrative record based upon the set number of requirements under TSCA. So the court, for example, found that in terms of EPA's determination that testing was needed in order to perform its risk evaluation for the substance, the DC Circuit upheld EPA's decision that testing was necessary.
Hmm.
This was so here the court didn't apply what might be viewed as a new Loper Bright framework to its decision. It didn't go through and parse out different parts of the statutory text in great detail, but it did ultimately determine that EPA's final decision was reasonably determined. So that seemed to be a signal to the new framework established under Loper Bright, which arguably the DC Circuit, the decision was only had only been published, I think, about 4 days
Yeah,
before.
4 days before, but it sounds like, the court relied upon a more traditional did the elements of the agency's review comport with what it needed to? But it seems like you're also saying, Kelly, that to some extent there was kind of a genuflection to Loper Bright in the Vinyl Institute case, given the nature of the analysis, but no citation to the then very recently issued Supreme Court ruling.
Right. And it did depart from past TSCA Section 4 cases, which concerned a different testing authority issued under 4A1. But notably, in past 4A, TSCA 4A1 cases, there was, um, an effort to go through the Chevron framework and determine, um, whether the statute was clear or ambiguous, and then determine if EPA's interpretation was permissible. So it definitely comparing the analysis in the Vinyl Institute case to past cases under TSCA Section 4A1, it did appear to be a difference in the approach to the court's analysis.
Mhm. And you've already mentioned a little bit about EDFE EPA, which was decided in December of last year, so the full impact of Loper Bright was certainly realized by 6 months after the issuance of the Supreme Court decision. Agree?
Right, exactly. So the EDF versus EPA case was also decided in the DC Circuit. This case concerned EPA's CBI rule that would carry out TSCA Section 14's confidentiality provisions. And here, the court really worked through various steps under Loper Bright. So, just to give an example, EDF had challenged EPA's regulatory definition of health and safety studies, which are not entitled to confidential treatment under TSCA. In the final rule, EPA had determined that certain categories of information in a study doesn't fall under the definition of health and safety study and could be claimed as confidential. So this would allow submitters to redact valuable information without impacting the ability of the public to access and interpret the study document. So in order to approach EDF's challenge here that EPA's regulatory definition of health and safety study and what wasn't in the definition of a health and safety study, to determine whether or not this violated TSCA, the DC Circuit dedicated a section of its analysis to determining whether this was the best reading of health and safety study. So first, the DC Circuit analyzed the statutory text, reviewed Congress's word choice, and determined that based on the terms used, Congress's definition of health and safety study applied only to the evaluation of a chemical's health and environmental effects not the entire document containing an evaluation. So the fact that a single document can contain a mix of information that is both exempt from disclosure, like the company that manufactures a chemical, and the evaluation of that chemical's effects, it doesn't mean that all information is then reportable or disclosable under TSCA Section 14. Some of that information
Mhm.
is still entitled to confidential treatment. So after it did that analysis, then the DC Circuit dedicated a, an additional section to comparing EPA's regulatory definition against this best reading analysis to determine whether EPA's interpretation is consistent with the best reading of the statute, reasonably explained, and consistent with past practice. And here the court considered also whether EDF's reading of the statute was consistent with TSCA. The court ultimately found that EDF's interpretation was difficult to reconcile with TSCA and would render certain protections under Section 14 as superfluous, whereas EPA's interpretation was consistent with this best reading. So the way that the DC Circuit worked through these issues in its opinion, it appeared to apply the Loper-Bright framework in a stepwise process to issue its own independent decision as to what's the best reading, and then ask the question, is EPA's interpretation consistent with this best reading? And is the challenger, in this case EDF, is their reading consistent with that best reading, and looking at different factors there.
Well, we'll put in the materials for the podcast, a citation to the EDF v. EPA case, because it sounds like readers would be well to take a peek at the passages that you just now expressly called out, because it provides some really good example of how do you determine what the best reading is? What are the factors that a court is going to look to? And that's now the law of the land, right? To go through this analysis, this Loper-Bright analysis, to come up with the best reading and enable the court to do its job, which it's certainly entitled to do under Article 3 precedent, to render the best interpretation using its independent legal judgment as to those factors that help the court identify and conclude what is the best reading of the statute. So we'll put reference to those passages in our materials to help readers understand what the new interpretation is. And we're probably going to be seeing other examples of that, Kelly. I mean, there's a lot of TSCA litigation right now, as most of our listeners, or as our listeners may know, all 5 final risk management rules that EPA issued in the fairly recent past are now the subject of judicial review. Maybe we ask your thoughts on how the demise of Chevron deference might influence the court's decisions in those cases. They're different circuits. They might go about interpreting the law and the demise of Chevron via Loper-Bright differently. But I suspect that the Supreme Court decision will make a difference. How has the doctrine been invoked, if at all, in any of the oral arguments that have taken place to date?
But you raised a very good point regarding variability in how Loper-Bright might be applied across different circuits. That was certainly one of the main critiques of the Chevron two-step process, was variances across circuits, and the challenges to EPA's risk management rules under TSCA are spread across various circuits. At this point in time, most of the risk management rule cases have been placed in abeyance while EPA is reconsidering its past decisions. So these requests for abeyance are based on the longstanding premise that agencies can review and, if appropriate, revise their past decisions, which would even
Mhm.
perhaps obviate the need for judicial resolution of certain issues.
Kelly, does abeyance mean the court continues to have jurisdiction of the case and it just, declines to make any substantive ruling and the parties don't have to brief? What does abeyance mean?
Yes, so abeyance means that the case is essentially placed on pause. I right,
Okay.
so either it's on pause because EP is reconsidering its past action, or because the parties are seeking a potential settlement of the issues. Um, but the court retains jurisdiction over the case pending abeyance.
And that's different from remand, right? Which the case kinda goes back to the agency for the agency to take action on it?
Yes, yes. So this was highlighted in the recent DC Circuit decision, to hold the case challenging EPA's risk evaluation framework rule in abeyance instead of remanding the case back to agency. So here, when during the oral arguments regarding EP's request that the court remand the case because it had issued a decision to reconsider the risk evaluation framework rule and committed to an expedited rulemaking process to issue a new risk evaluation framework rule within a year. The EPA had requested remand, which essentially would mean that the case would have been closed, um, versus what ended up happening, which was the decision by the DC Circuit to hold the case in abeyance while EPA pursued this reconsideration process. So that means that at the time when EPA does publish a revised risk evaluation framework rule, the current petitioners in the case challenging what would then be the old rule, or the rescinded rule, they have a live challenge up until the point when essentially the rule is replaced. So some of the discussions there, in the argument for remand versus abeyance, some of the arguments there pulled in, the applicability of Loper Bright, given that the case really raised issues regarding statutory interpretation and how EPA's framework rule would carry out provisions of TSCA as specified in TSCA. So one of the
Mhm.
questions there was, this is the purview of the court to decide how EPA should carry out TSCA, even though the court ultimately agreed to hold the case in abeyance. One possibility is whether the court should proceed to decide the case on the merits and decide the statutory issues before EPA embarked on this reconsideration process. Um, so even though that wasn't the ultimate outcome, it was interesting to see how the discussion then tied in Loper Bright, and how this would impact cases, not only when the court is deciding the case and issuing its opinion, but also determining issues such as whether or not to grant remand or hold the case in abeyance.
I think that distinction, I know it's a subtle one, and we're getting a little in the weeds here, but it's a fascinating issue for those of us that are hanging on court's every word in framing these issues. And for the risk evaluation framework world, it's just, to me, a very anomalous situation TSCA stakeholders are in. You have a court reviewing the merits of the application of an existing framework rule while the new administration is actively engaged in reimagining the framework rule. So there's a lot of differing opinions on what courts should be doing out there. So readers may want to be especially attuned to that case because it's a very interesting one. Well, let's turn to what some of the fallout of Loper Bright is. I know there's been an awful lot of speculation on a couple of different aspects of advocacy. So, two questions for you, Kelly. How will the demise of the Chevron deference doctrine influence legislative advocacy? It seems to me, to the extent that ambiguities in the law, which are, of course, legion coming out of Capitol Hill, it seems to me advocates now will want to be as explicit as possible in defining key terms in any legislation, not just those relating to environmental or chemical law. And then similarly, how might administrative advocacy now progress in light of the demise of Chevron? So first, legislative advocacy. What do you think it's going to, how is it going to be impacted?
Sure. So, one of the reasons for the Chevron deference framework was because it's impossible for Congress to account for all possible outcomes and issues in a statute itself. So, under TSCA, for example, Congress establishes both detailed and precise requirements directly in the statute, and in other cases, directs EPA to promulgate rules to carry out the requirements. And for example, leaves several significant terms undefined. So, unreasonable risk, for example, is not defined under TSCA.
Mhm.
So, in terms of potential changes in approaches to legislation, one possibility is that in order to eliminate room for doubt as to what Congress intended, Congress could make it explicitly clear when it's delegating authority to an agency to interpret and further carry out statutory provisions, or it could be more precise in terms of the definitions or terms that it includes to the extent possible.
That's tricky though, recognizing that it's a agency, in this case, let's use EPA, with many, many decades of experience interpreting very nuanced data and applying very sophisticated scientific terms within a legislative and administrative framework. So on the one hand, I can see Congress's desire to be more explicit in its legislative writing, but also allowing ample opportunity for an agency to do what it does best, which is deploy its considerable expertise in interpreting terms. So it's a very fine line, and it's going to be interesting to see how Congress, discharges its obligations in light of Loper Bright and the demise of Chevron. What about administrative advocacy? Now that we are writing as many comments as we do on various proposals under EPA's task implementation program, what thoughts do you offer for advocates in commenting on, for example, proposed TSCA rules and other, similar advocacy opportunities?
Right. So, in terms of participation in administrative advocacy, there's a lot of emerging emphasis on what will constitute the best reading of the statute. So, as we saw in the development of EPA's risk evaluation framework, for example, certain policies and statutory interpretations can carry through across differing administrations, while others could vary based upon certain policy goals or in response to public comments or in settlement of litigation, as well as other evolving factors. So, in looking at the impacts of Loper Bright when preparing public comments, for example, if viewing potential judicial review as looming or or envisioning what the potential outcome of a judicial challenge could be, um, it might be helpful for stakeholders to look towards the long-term implications of an interpretation with a focus on legislative history under TSCA, as this could ultimately be more persuasive when making arguments in public comments about what a certain interpretation or framework should be as EPA carries out the various very technical requirements under TSCA.
Great. No, that's very helpful. It will be incumbent upon all of us, certainly in the chemical space, to understand as well as we are able what the implications of Loper Bright are, and really be advocating for that best interpretation. It's going to be a real burden on advocates to bring their A game to these very complicated issues that we're confronting.
Right, exactly.
Kelly, where might listeners get more information on this topic?
BNC has a couple of events coming up that will provide some additional insights into recent TSCA litigation and the impacts of Loper Bright. BNC also has an upcoming webinar with our colleague James Idala, who's a senior government affairs consultant at BNC, where we will discuss issues relating to Loper Bright and the revocation of the Chevron doctrine in additional detail. So the webinar will take place on July 15, 2025 at 11 a.m. Eastern, and we hope that you all will be able to tune into that.
Great, Kelly. Those are great, great thoughts. And I'm really looking forward to the July 15th webinar where you and Jim and I will talk about these topics in much more detail. So, Kelly, thank you so much. This was hugely helpful in understanding what exactly the demise of Chevron means, getting an understanding of what other forms of deference remain firmly in place, and how to comport legislative and administrative advocacy in the months and years ahead. So thanks for being with us today.
Thanks very much for having me.
Thanks again to Kelly Garson for speaking with me today about the demise of Chevron deference and what it may mean for TSCA litigation and TSCA implementation. All Things Chemical is produced by Jackson Bierfeld at Bierfeld Audio, LLC. We will be back again soon to further inform and entertain you about all things chemical. Bye-bye.